So once again, thank you everyone for giving us your time this evening to help us kind of present the draft land use bylaw for the Summer Village of Sunbreaker Cove. This draft is presented as a modernization and focused review of the Summer Village's current land use bylaw. All municipalities in Alberta are required to have a land use bylaw, and it's a good idea to ensure that they're up to date with provincial rules and regulations, and that they reflect the values of the community and things that are in your other planning documents and other bylaws. Um, we are recording this, as I had mentioned previously in the preamble, for anyone who's unable to attend or view, so that they can watch at their own convenience. And without further ado, here we go for the open house. So what we'll cover tonight are information about what a land use bylaw is, what is in the current land use bylaw for the Summer Village, what some of the more focused review objectives have been in putting together this draft land use bylaw as reviewed by administration and council, um, and what some of the modernization elements of it are to ensure that it's current with all legislative requirements as set by the province. What the process has been to date to get us to a point where we have a draft that is available for community input and presentation. Uh, I guess part of the meat of the discussion tonight will be presenting a summary of the proposed changes in the current draft and how it differs from the current land use bylaw that's on the books now for the Summer Village. On the Summer Village's website currently right now, there is a copy of the draft. And within it, we've done our best to identify the changes that are reflected within it. And by doing so, we've identified proposed new changes in blue font, proposed revisions, deletions in a strike through font, and anything that isn't broken that can be carried forward into the current draft from the current version is shown as just regular black text. We've also done our best to identify what some of the revisions council has made to a previous version of the draft that was internal only. So you can get a sense as to how this draft came about. And once we go through the proposed changes, we'll also talk about the next steps. This isn't the final process in preparing a land use bylaw or updating one. There's still public hearing requirements, agency notification, and council's opportunity to review all the feedback that's provided to us, so that we can revise the draft accordingly as part of all the feedback that we receive. So what is a land use bylaw? A land use bylaw is a bylaw that is mandatory for all municipalities in Alberta to adopt. It is whether you're the city of Edmonton, the Summer Village of Sunbreaker Cove, Red Deer County, any municipality in Alberta has to have a land use bylaw. It's often the longest, biggest, kind of most verbose bylaw any municipality will adopt, because it has to cover a lot of different topics. It is the bylaw that establishes what the processes are for applying for a development permit, what the processes are for applying for a subdivision, and also what the processes are for the development authority and the subdivision authority to review those bylaws and provide notification and make decisions at the end of the day. It's the bylaw that covers how land use and development enforcement occurs, how appeals to decisions are made, and sets the regulations for specific and general types of development. So if you want to build an accessory building, a shed, a garage, the land use bylaw covers all the measurements and details about how far it needs to be set back, how big an accessory building can be, how many you may have on a lot. Same for homes, and if you're going to be clear cutting a lot or doing major landscaping work, what the rules and regulations are surrounding that as well. So a land use bylaw is something that covers anything really to do with land use and development in your community. And unfortunately, to do so in a way that is effective, enforceable, and defendable if gone to appeal. It needs to be it needs to have a lot of content so that the appropriate authorities can point to specific sections and regulations for you to follow as a development proponent. Um, the Municipal Government Act, which is an overarching piece of legislation by the province, kind of sets what a land use bylaw has to include. And there are a fair number of topics in there. In addition to that, land use bylaw also has to be consistent with all those provincial rules and regulations within the Municipal Government Act and other acts and regulations such as the Water Act and wetland regulations and things of that nature. The Summer Village's current land use bylaw has been on the books for a little over 10 years now, bylaw 9913. It is, again, a long document. It's approximately 68 pages long. It's certainly not something that you can easily read before you go to bed. I certainly wouldn't try to do that. Um, one of the things that we'll note about it is that it is not terribly old. We've worked on updating land use bylaws from the 80s very recently, which are terribly out of date with regulations and policies of the province. But it is out of date with a lot of rules and regulations that were fairly significantly enacted in the last few years on the part of the province that relate to the Municipal Government Act. This land use bylaw, as we'll note with all land use bylaws, are not written in stone. This one's been amended 5 different times to address different matters that have arisen or changes that have been needed to reflect community priorities. So land use bylaws, once they're adopted by council, they can be, the following day essentially be amended to fix different approaches to add new content that wasn't envisioned before. If we're talking about having a new style of housing that is very important to the community and it's not addressed in the land use bylaw, you can amend your land use bylaw to include provisions for that. So this particular land use bylaw has been updated a couple times, most recently in 2020. But it is not consistent with the Summer Village's intermunicipal development plan, which is a planning document that's shared by all municipalities around Sylvan Lake. And it sets future land use objectives for development around the lake. It's adopted by the 2 counties and all the Summer Villages and the town of Sylvan Lake as well. And in it are guidelines for when you do review and update your land use bylaw, some things to include in it that help protect water sources and important environmental features that lead into Sylvan Lake. So having set the stage for what the current land use bylaw is for the Summer Village, one of the things that is important to us is identifying what the objectives are for undertaking a review of a bylaw like this. So working with council and administration, we were approached to help kind of update the land use bylaw to meet some important objectives. These include, kind of as I was covering a bit before, to ensure that the land use bylaw is consistent with all updated provincial legislation and regulations. It's very confusing for administration, let alone residents, to have a land use bylaw that says one thing, but you have to refer to the Municipal Government Act, which overrides it on a different in a different section. So you have to keep referring back and forth between 2 different major documents, and it can be a bit confusing as to what is most current with between the 2 documents. Again, we have to be consistent with the Summer Village's planning documents that set important visions and policies for future land use and development. So these are your intermunicipal development plan, which is shared with the other Summer Villages around the lake, as well as the Summer Villages municipal development plan, which sets your vision and goals and objectives and policies for what you want to see happen in the summer village in the future. So in reviewing the land use bylaw, we had to look at these documents to see what needed to be pulled out so that everything was consistent. Reflect current property bounding and mapping information. Not a whole lot has changed in the summer village in terms of line work, but we just needed to make sure that all of that information was in there. Reducing red tape where possible. Unfortunately, that doesn't mean removing a ton of regulations or reducing the overall document size, but largely with the land use bylaw, what that means is helping to identify specifically what application information will and may be required so that there isn't confusion and misunderstanding among development proponents or anyone looking to redevelop a lot and administration in terms of what application requirements are going to be asked for particular types of development. This way, everything kind of gets put out into the open. We've also done a fair bit of work to ensure that all major terms and verbs and types of development that could be developed in the summer village are properly defined so that there's common language between everyone sitting around the table in terms of understanding what is being asked for, what different reports mean, and what different types of development are. A manufactured home to one person might mean what you would traditionally see in a trailer park. For another person, it might mean like a modularly constructed, ready to move, single detached dwelling. So we've done our best to help clarify a lot of the information, which helps expedite and provide a better understanding of what development permit application requirements would be. Where possible, we were able to identify some kind of overlapping content in the land use bylaw, and I think at the end of the day, it's going to be shorter than the 68 pages that it began with. We've done our best to identify some modern land use and development pressures that are facing not only this summer village, but other summer villages. Specifically in terms of ensuring that watershed management best practices are incorporated where appropriate and where council felt that they were appropriately scaled for the summer village. And I kind of on top of that, implementing those best practices where appropriate. So to date, we began by meeting with council and administration to discuss, their priorities for this project and what was important for Summer Village.
I haven't heard anybody yet.
Sorry, just 1 second. And what they felt was most important to include in the updated land use bylaw. So meeting with council, we had that information to begin with. We then prepared a draft land use bylaw for council's review. Reviewed that with council, I think in 2 different meetings and a few different emails to kind of refine the draft to get to the point where it is today. And I'll keep reiterating the word draft. This is not a document that's prepared and I guess ready for approval and what needs to be used. But it is a document that between our office, administration and council, we felt is at a point where we can present it to the community for your input. We prepared a newsletter information pamphlet that was, I guess, put on your website and distributed to community members, just letting you know about this process going on and that there would be this opportunity in the near future. And we're just happy to kind of get it to this point right now. We'll talk more about the next steps once we get through the summary of proposed changes, but this is to the point where we're at right now. I'll reiterate too, as we kind of talked about on the first slide, if anyone has any questions as we go along, please put them in the chat directed at me or Kara with the Summer Village, and we can raise them as we hit each different slide here in terms of the content, or we can answer them once we get to the very end. So the proposed changes in the land use bylaw. This is probably what you're here for mostly. And I just want to go through section by section at a bit of a higher level, what each section means and what some of the content and proposed changes are. We began the document by including a page where amendments can be listed. I think the Summer Village has done a great job identifying on the covering page of the current land use bylaw that there have been amendments to the land use bylaw and what those bylaw numbers are, and that they're included as basically a stapled on page to the bylaw. Um, with I guess modern technologies and Microsoft Word and whatever, it's much easier now to just go back and make those changes as amendments come along. But it's important to include a page to identify that changes have been made to the land use bylaw, and this will give an opportunity to identify not only the bylaw information and the date, but where in the document and what the change has been. So if we're allowing casinos in the Summer Village of Sunbreaker Cove, and that was an amendment that council decided was something that they wanted to consider, that there be a line item in there that indicates as such. I'll reiterate that casinos aren't on the table as far as I'm aware, but just wanted to provide something that would seem a bit more memorable. That page is not approved as part of the land use bylaw, so as each amendment came in, administration can just add it to the document without having to go through an amendment to add an amendment. We also added a land use bylaw user guide, also not approved as part of the land use bylaw, but it's a little bit of content that helps provide an understanding of what the land use bylaw is and how to use it. It is, as I was mentioning before, often the longest and most complicated bylaw that any municipality is going to adopt. I work on them, on a daily basis, and I often get confused by it. If you ask me a question about a particular land use bylaw, I have to, ask you to, give me time to get back to you, because you cannot just read one particular regulation in isolation usually. You have to refer to a few different sections to make sure that what you're proposing to develop or what you're looking to do can be done. So this page just gives a bit of a preface as to what the land use bylaw is and how to use it. The introduction section is kind of getting into the actual meat of the document, although it is a bit more preamble than other sections within it. A lot of the content in here is remaining from the current bylaw. It's just been updated to reflect a few purpose items, to include reference to the intermunicipal development plan and the importance of preserving the health and quality of Sylvan Lake. Repealing the repeal section would identify that the current land use bylaw, or the previous land use bylaw, I guess is the better way to put it, has been repealed, and that this is the only land use bylaw of the Summer Village. Right now, your current land use bylaw has a line in there that repeals the previous. This one will just be updated to reflect that the current one today has been repealed and replaced with this land use bylaw. It also includes housekeeping information about compliance, that all land use and development activities have to be in compliance with the land use bylaw, as well as all provincial, federal, and other requirements. The severability section deals with the fact that if tomorrow a provincial change to the Municipal Government Act were to make a regulation in the land use bylaw not applicable anymore, that the entire land use bylaw isn't thrown out, that one particular regulation would be severed from the rest of the bylaw, and the rest would continue on. And information about forms, how they're created, how they're maintained, and what the fees are, and how the fee information is found. So a lot of the content in, although it's identified as updated in section 1, is very similar to what you have in your current land use bylaw. The authority section covers all of the different important groups, actors, and organizations that have a role in enforcing, implementing, and using the land use bylaw. We've updated it to reflect a few different groups that were not identified in your current land use bylaw that have important roles. Council's most important role in a land use bylaw is adopting a land use bylaw. At the end of the day, it is their document to consider for adoption. But they also have a role in considering amendments to the land use bylaw. And if you were to have a direct control district, which would be for an area with very specific and special development considerations, uh, council would be the development authority for that area. We've updated the development authority, development officer, and municipal planning commission content a little bit to just reiterate who the development authority is. And in the Summer Village, for some decisions, the development officer makes the decision. And for anything, um, I'm drawing a blank right now as to what the exact parameters are, but municipal planning commission deals with the more complicated and more discretionary development decisions that happen in the Summer Village. So we've updated those sections just to clarify what the roles and responsibilities are of each. The Summer Village is probably not getting a ton of subdivision applications, but there are requirements in the Municipal Government Act that all land use bylaws have to cover subdivision matters. All municipalities have to have a subdivision authority. So we've included information about how the subdivision authority would operate within the Summer Village if any lands were to be proposed for subdivision. Same for the Subdivision and Development Appeal Board. In the appeals section of the land use bylaw, there's processes that that board would have to follow. It is not something that was covered in the current land use bylaw, so we added it in. Not that currently today it would matter too much, but it's always important to just identify what the different authorities are. One of the longest and most important sections in this draft land use bylaw is the interpretation section, and this is your list of definitions that cover a lot of land use and development activities that either are permitted uses, discretionary uses. So permitted uses are things that if you are in compliance with the land use bylaw and you satisfy all the application requirements, it's a development that has to be approved by the development authority. A discretionary one would be one that provides the development authority of discretion as to whether it is an appropriate development for that particular location. So all of those different uses that could be developed in your community are defined in the interpretation section, as well as a few that are defined and not listed. So if a use is defined but not listed, it is considered to have been thought about by council and specifically excluded so that it cannot be considered a type of permitted use or a type of discretionary use. The interpretation section also includes a lot of technical terms as well as those specific uses, just to be able to provide common language between residents, development proponents, and administration and council. So everyone is talking about the same thing. If we're talking about an adjacent landowner, it would include notification requirements for sending things to an adjacent landowner, which is not necessarily someone who lives close by, but shares a common boundary between the subject site and an adjacent lot. We've also included technical terms that have been assisted by Summer Village's legal counsel in other land use appeals and decisions. Things like defining the escarpment, what high water marks are, what landscaping is, and other things that we've noticed in our professional review of other land use bylaws, what is needed to help provide some support and backing so that there's an understanding of everyone around the table what these type of things are. So this section, the interpretation section, is a bit longer than it is today. I think currently right now you have about 90 different definitions. In the draft land use bylaw, I think there's identified up to number 200 in there, but a few of those are to be deleted. So unfortunately with the numbering, those ones also get numbered. So I think at the end of the day, that content will be reduced to about 150. And it does add for more pages to the land use bylaw, but it hopefully at the end of the day will make the interpretation of it a lot easier for some folks, especially when we're talking about things that aren't defined currently, and then there's confusion on one or more sides as to what a particular use or activity is. Section 4 deals with the amendment. As mentioning before, a land use bylaw is not something written in stone. It can be amended. It's not easy to amend it. It's not something that council can just wave their magical wands and have done overnight. An amendment to a land use bylaw requires an application. It requires consideration by administration and by council. It requires a public hearing process, an adoption process, which includes 3 different readings, which can't be all held on the same day. So to go through an amendment process is not simple by design, so that it is given careful consideration. But this section, which is something that has a little bit of content in your current land use bylaw, but we've updated it to more clearly identify what the process is for applying for an amendment. Any resident or community member or really any person can apply for an amendment to a land use bylaw. If that was to add duplexes, for example, to lots, or to increase the height of dwellings, increase the number of accessory buildings that can be allowed on dwellings, or to have an amendment that says all homes have to be painted blue. Anyone can apply for one, but it's up to council to consider it and determine whether it will be given first reading and go through the public hearing process. So this section has been updated to just make sure that that process is understood by everybody. Section 5 deals with development permits. And for each subsection within the section, I've kind of created a different line item here because each one is kind of worth mentioning in on their own. A lot of land use bylaws kind of have these scattered throughout their document. But our approach has been anything that deals with development permits should kind of be lumped together under a development permit section, so that applying for them, processing them, and going through the notification and approval processes is all understood sequentially. So this section describes what that process is for applying for a development permit and the review of it. We've updated it to reflect what your development authority would typically be asking for today. Your current land use bylaw indicates that there are some application requirements, and also any additional information that the development authority may require. Our approach has been to spell out what some of that information may be, so that there is clarity as to what some of the technical reports and studies may be for the purposes of development, so that there is clarity on what those may end up being at the end of the day. There is some leeway on the part of the development authority in terms of what must be included as part of the development permit application, but also some things that may be required when the scale of the proposed development is such that additional information is required. And development permits are an important thing for a municipality. They're kind of the assurance that development that happens in your community is done properly, that it's done orderly, economically, and done safely as well. It identifies what the responsibilities are of the municipality, what the responsibilities are of the development proponent, and it kind of ensures the continuance of your community is somewhere where things are done in an orderly fashion. All summer villages that we've worked with kind of go through this, where a lot of development has, is through the development permit process, and the summer villages Sunbreaker Cove is not unlike any of the others. Section 2.5 in this overarching section dealing with development permits is provides a list that's pretty important, and I implore anyone to have a look at if you haven't had a look at the draft land use bylaw yet. But it lists what the types of developments are that do not require a permit. There are some minor, smaller, less intrusive types of development that don't require a permit. Inversely, if it's not listed here, it does require a development permit. So it's important to have a review of this and making sure that things that you wouldn't want to have to burden your administration, development authority with having to review and provide development permits for, you want to make sure that they're listed in here so that that process isn't too clogged down. We've added a few things that we felt were important and clarified a few others just to clarify what doesn't require a development permit. Things like identifying what the maximum of three, I say movable, but it's smaller accessory buildings that don't exceed 11.1 square meters or 120 square feet. Right now, that's almost verbatim in your current land use bylaw. It just identifies accessory buildings of that size. So working with council, we've identified a maximum number of them. Inversely, if you want to go beyond three, the fourth one, the fifth one, the sixth one would require a development permit based on how things are written in the current draft. Other things that we've added in here that we felt were, noteworthy include retaining walls, building them, repairing them of walls up to 1.2 meters in height, and that's consistent with the Safety Codes Act. Sorry, the National Building Codes Alberta edition. Same for minor home occupations, operating a business out of your home when you're not receiving, a ton of visitors or using the outdoors to, store a bunch of materials or anything like that. That doesn't require a development permit or shouldn't require a development permit. Micro wind energy systems and roof mounted solar energy systems, things that help, make your home more efficient or power minor landscaping features in your yard. Those shouldn't require a development permit in our opinion. And any landscaping that doesn't affect on-site surface drainage or affect your neighbors essentially or the lake, doesn't require a development permit. And we've also clarified a bit in there too about regular yard maintenance, regular building maintenance, things of that nature. So our approach has been to add things to the section, not delete, so that there's clarity on that. 5.3, non-conforming buildings and uses. In summer villages, you often have a lot of older homes, older buildings, old cabins, and on lots that might have been created a long, long time ago and aren't, that wouldn't be consistent with the current land use bylaw or this draft land use bylaw in terms of setbacks, building heights, location on the lot, that sort of thing. The Municipal Government Act covers how those types of cabins and homes and other buildings are dealt with, so that there is a process for those buildings to be considered non-conforming buildings and uses, and that they can be continued if you need to do minor renovations and updates and other development on your lot. It can be done through a process that the land use bylaw contemplates. It doesn't mean that if you're building a shed in your yard, you have to jack up the home and move it onto the lot properly necessarily, just because you're not up to date with current setback requirements. Inversely to, if for any building or development that was approved or allowed, has a development permit from an earlier time or from a different land use bylaw, this enables those to continue as well. It's kind of like grandfathering in. I guess a lot of people kind of use that terminology, even though that's not in the Municipal Government Act. But that's generally the approach there. So if you were allowed to, if you went up legally, you can legally continue. If an unfortunate situation arose where your home was, completely gutted by fire or something along those lines, you would have to redevelop the lot under the current land use bylaw. But if you needed to do minor renovations to an existing non-conforming use, there's a process for that to continue. I covered a bit about the application requirement section. Our approach on this with administration and council has been to just update it to reflect what the development authority is asking for today, rather than just saying anything that the development authority may want. We've included examples as to what some of those may statements may be. So there are things like geotechnical reports if it's felt that the ground is unstable or getting a little too close to the lake, landscaping plans to ensure that the lot is landscaped appropriately. If there happen to be wetlands on the lot or in the area, in the immediate area, a wetland assessment as per provincial requirements, providing post-construction site and building elevations, things that can be provided by your surveyor and your builder, and kind of as they're working on the site. Real property report for new buildings in addition, or if it's felt that things weren't located where they were supposed to be. So this section includes those must statements, but also a lot of may statements as well, and not just to make the document longer, but to provide more clarity on what some of those things may be, so that it's more defensible if there are things that are needed. Permission for demolition is kind of updated content in your land use bylaw. If something requires a development permit to go up, or should have, it should probably require a permit to come down as well. And that's just to ensure it's not to say that you can't take something down. It's just to make sure that it's done properly and safely. So if it's an older cabin that potentially might have asbestos and other hazardous materials within it, that's taken care of properly, to ensure that all materials are to be disposed of appropriately, that we're not in a situation where the lake is now filled with debris from asphalt shingles that got pushed into the lake accidentally, and that there's a plan for dealing with the site and when the work is going to be done and completed by. Sorry, there was just one question that kind of popped up along the way in the chat. In the development section, who determines what may be required? That would be the development authority. So in the case of permitted uses and other minor development permit applications, that would be your development officer, who kind of has the professional knowledge of understanding situations where dealing with banks that may be unstable, or dealing with the escarpment, situations where they may be asking for things that they wouldn't ask for something on a back lot that's a little bit further away. Similarly, the Municipal Planning Commission, as the development authority, could direct the development officer to request those as well. So the may statements, the may content in the application requirements are a decision of the development authority. At the end of the day. And I don't think that they're out there to ask the world for someone putting in a small accessory building, but they're in there to deal with any potential situations where things like that may be required, so that they can determine whether the proposed use or development is in a suitable location and suitable for the area in which it's being proposed to be developed. So hopefully that answers that question. And if anyone else has anything along the way, I'm happy to answer those in the chat. Sorry, I think I went a little too far. Permission for demolition. I was covering that a little bit, but it does cover what those application requirements would be, so that there is a process in place for demolishing a building that may have impacts not only on the lake but adjacent properties as well as municipal infrastructure when you're bringing in heavier equipment. Removing a home or a large accessory building. The processing and development permit applications. This just identifies what that process is for once a development permit application is received and all that information is provided, how the development authority deems it complete, and the timeline that they have to process the application. and what their process is to consider it and get it to the point where it's either going to be asking for additional information or getting to a point where it could be decided upon in terms of allowing or disallowing the proposed development. Development agreements are tools that are conditions on that development permit. And this section just identifies what some of those conditions may be and when they may be utilized. So it identifies what types of development may require agreements with the municipality, the summer village. And these agreements may be things like providing in writing essentially agreements that if it road needs to be extended, and this would probably be more of a rural or if you had land that were to be developed in the future, but construction of road to access the development, that be part of the development agreement. An agreement that lot grading will be completed, so that isn't skipped over, and that if that needs to be done by the municipality, that there's a development agreement in place for that. Providing for the control of offsite drainage and requirements for the proponent to be responsible for any damage that may be caused to municipal infrastructure. So whether roads, culverts, ditches and other stormwater systems, municipal reserves and other park areas. If a heavy vehicle happens to, destroy um, the landscape, that's something that would be included in the development agreement to ensure that all that stuff is covered. Just a follow-up question on the May statements. Someone had if there's a disagreement on what is to be required. So if a development permits application is received and say there's a wetland on the site, and the development authority said that wetland assessment has to be provided. The applicant said, I don't think one has to be provided. I don't think this is actually a wetland. There is a process where the application can be deemed refused, and it can be appealed. So the appeal would go to either the Subdivision and Development Appeal Board, which is the local body that deals with subdivision and development appeals, or it could be determined that it goes to the Land and Property Rights Tribunal, which is a provincial appeal body that covers development matters, subdivision matters, and development matters that deal with things of a provincial interest. So if this was near a highway, near a major water body, which it is, or dealing with environmental features of provincial significance, it could potentially go to the Land and Property Rights Tribunal. I don't bat 1,000 on understanding fully, which appeal body it would go to in this particular scenario, but it could go to an appeal. And it could be determined by the appeal body as to whether that is something that has to be provided or has been properly addressed in the application already, and if it's just being a frivolous ask of the development authority for that information. So if the development authority was asking for a noise study because someone was building a new shed, that might be considered a bit much, and the appeal body could determine that that's not appropriate. But at the end of the day, it's a determination of the development authority as to whether that's an application requirement. But there is that recourse for an appeal on the part of on the development permit applicant, and there are timelines that need to be met so that this isn't something that drags out. An application can be deemed refused after a particular date by the applicant, so that they can begin that appeal process. Variances are something that's covered in the Municipal Government Act, but they allow the development authority to consider allowing permitting a type of development or development to occur if it doesn't comply entirely with the land use bylaw. So if you are looking to develop something on your lot and you can't quite meet the setback requirements because of how your lot is configured, or because there's a significant development, hazard or feature on your lot, and you have to be a little bit closer to your neighbor's line, um, you aren't necessarily out of luck entirely. You can apply for a variance. The Municipal Government Act allows for this. All land use bylaws allow for this, but they're not always written directly into the land use bylaw. So we've identified what this is, and that a development permit variance request can be asked for. These are things that would go to the Municipal Planning Commission, as I understand. Um, and I think that's the way in which things currently operate in the summer village and all the summer villages, mostly. Um, but we've just provided a bit of insight in this as to what the development authority must consider when reviewing the variance request. And that variances aren't going to be granted for things like exceeding maximum parcel coverage on a lot. So you can't just have a bigger um, dwelling on your lot because you want it. Um, that's something that's kind of set in stone in the land use bylaw, or the height of a building. So you can't just get 1 foot taller just because your neighbor happens to be of a certain height and you want to be just a little bit taller than them. So those variance provisions are written into the land use bylaw, but there's something that's already provided for in the Municipal Government Act. Same for the notice of the decision. How decisions of the development authority are granted are outlined in the Municipal Government Act for how that's done. So we've just updated the land use bylaw to reflect what the format of that has to be, what the timing of it is, and what the timing is for a development authority essentially taking effect. Sorry, the development permit essentially taking effect. Cancellation of permits, there's no changes here. It just identifies that a development permit can be canceled by the development authority, and for what reason. So if incorrect information was given, if things were falsified, that's another example, or if an error was made by the development authority, that permits can be canceled in those extreme situations. Compliance with other legislation covers just a reaffirmation that any development permits or other permission given under the land use bylaw doesn't give you diplomatic immunity to flaunt provincial, federal regulations, other municipal policies, or any compliance with any easements, agreements, or caveats that you might have on your land. So just because you have a development permit doesn't mean you can um, you can say, I got a development permit, I can do whatever I want. You also have to follow all those other levels of government and any other legal agreement that affects your land. Section 6 is a whole new section that we added that deals with subdivision applications. And as we were mentioning earlier, I don't think that the Summer Village is going to have a big run on subdivision applications, but subdivision applications can be applied for. Between either lot splitting or consolidations, there are subdivision applications that do happen in summer villages. If you were to annex a large piece of land from the county, you could potentially be looking at subdivision in that area as well. So we've just identified what that process is, because that's not something that's anywhere in any of the summer villages planning documents. So it's good to just identify what that process is. And there are some very minor, but very much required subdivision processes that all municipalities have to identify in their land use bylaw. So it just makes sense to include a quick 2 pages on what subdivision applications are. The appeal section, as kind of we were covering in the question here, deals with how and when an appeal can be heard, by who, sorry, can be applied for, by who, and where it goes. So if you get an application for a development permit and it gets rejected, you can appeal it. Similarly, if it's approved but with conditions that you're not favorable to, you can appeal that as well. And it can either go to the local subdivision and development appeal board or to the Land and Property Rights Tribunal. Again, in situations where there's a certain set of provincial interests at play. And administration and our office have a pretty good understanding as to what that would be in different situations. Sometimes we refer things to the Land Property Rights Tribunal, and they indicate that they would not be the appeal body in that situation. We've separated out the different processes for development and subdivision appeals, which are very similar, but have very minor differences that just make it, in terms of, for clarity purposes, we've just separated out between development and subdivision, and what the requirements are for holding a hearing for a subdivision or development appeal. Section 8 deals with enforcement, which sounds scarier than it probably is at the end of the day, but it's an important section to have in a land use bylaw because if you are doing development without a development permit when you needed one in the first place, or if you are in those early stages or are violating the land use bylaw in some sort of way in terms of operating a use or an activity or a commercial component of on your lot that if you're operating that casino that we were talking about, you could go through that enforcement process through the land use bylaw. So what we've done our best to identify in here is what this the incremental process is for enforcing the land use bylaw and development permits issued under it. We've done our best to just identify that enforcement content in the section is not only provided for in the Municipal Government Act, but is specific to the land use bylaw. So all other bylaws and other rules and regulations of the municipality, those have their own enforcement processes, whether dealing with a peace officer or the municipality itself. But this one just deals with land use and development matters. So we've identified that development and subdivision activity in your municipality can't contravene the land use bylaw or any conditions of a subdivision or development approval. That if you are in that situation, that the Summer Village can issue violation warnings, which is essentially, and you could also be in a situation where if you're building something on your lot and your development officer happens to be walking by, they can, let you know verbally and give you the opportunity to correct it yourself. But there are warning opportunities as well, which are issued in situations where corrective action can be undertaken to, fix the problem before it gets to a stop order situation, or issuing fines. The land use bylaw identifies what that process is for issuing stop orders. So if you are violating the terms of your development permit, or if you're building something that is not as identified in your development permit, that stop orders can be issued to, stop the development and make sure corrective action is taken. And if it's determined appropriate, fines and other fees can be issued to ensure corrective action is undertaken. Violation tags and tickets are also identified in here. Tags are something that's voluntarily paid for, maybe issued by the development officer, just to ensure voluntary compliance. But if we're getting into more serious nature, it's something that would be issued under a ticket that would be issued by your local peace officer. And that's something for mandatory compliance. So those are the major violations that kind of get to that point where the Summer Village is taking things fairly seriously. So all of this process and all of these options are currently available to the Summer Village through the Municipal Government Act. But it's important to identify in the land use bylaw, what these steps that the municipality may take to ensure enforcement are, so that it's in a spot where community members can find it without having to read provincial acts and regulations to sift it all out. Getting into I guess some of the more exciting content in the land use bylaw are the land use regulations. If you are looking to develop particular things in your community, or looking to do different land use and development activities. Hopefully there's a section in here that addresses the ones that are most appropriate for your community. This is content, a lot of this content is from your current land use bylaw. Right now, your current land use bylaw covers about 20 different general and specific land use categories, ranging from things like home occupation, building fences, dealing with mechanized excavation, stripping and grading, um, uh, development of public properties, using sea cans, when trees and shrubs need to be planted on a lot to kind of cover redevelopment and development activities. So there's about 20 sections in here in your current land use bylaw today. We added 3 or 4 more new ones. Some of these got pulled and combined in some situations. So approximately, I'll use that language, approximately 4 new ones are added, and they're the ones shown in red. So that's keeping of animals, which is also highlighted in yellow. Anything in yellow, I've got a few extra slides here just to kind of go through some of the major changes to the land use bylaw. But keeping of animals, covering your making sure it's consistent with other bylaws in the summer village. Manufactured homes and park model trailers, dealing with secondary suites, so suites within principal dwelling. And anytime environmental reserve is to be provided as part of a subdivision, it's something that your intermunicipal development plan shared with the other summer villages in the counties have identified as something that you'll have in your land use bylaw. So we've added it to be consistent with that policy requirement. So I'll kind of go through a few of these, and that'll get us through the end of the evening here. And if anyone has any more questions in the chat, I'll be happy to answer them. Or if you feel your questions are more appropriate for asking verbally, we can allow folks to unmute if needed. Accessory buildings and garages. There are technically 3 different sections in the land use bylaw that cover accessory buildings and garages. There is the section that deals with developments that don't require a permit. So some accessory buildings don't require a permit today, and as well as in the draft land use bylaw. And in this section 9, we have a section dealing with regular accessory buildings, as well as one dealing with garages. So in your current land use bylaw today, any accessory building with a floor area less than 120 square feet, and other kind of maximum height requirements. I think it's drawn a blank here, but I think it's 9.8 feet in height, and it also has to be movable, can be developed without a development permit. So you don't require a development permit for those smaller shed type accessory buildings. Today in your current land use bylaw, maximum height of any accessory building can be up to 15 feet. If you have a garage suite above it, it can be up to 25 feet. And an accessory building's floor area shall not exceed 8% of a lot area. And there's provisions for where it can be developed on a lot. So whether you're a lakefront lot or a back lot or a non-lakefront lot, there's provisions for where it can be developed. In the draft land use bylaw, we didn't make a ton of changes. One of the ones that we did clarify in section 5.2 is that you can have a maximum of 3 accessory buildings, of those smaller accessory buildings, without a development permit. And this is to ensure that lots aren't being covered entirely, well, not entirely, but by multiple smaller accessory buildings without any sort of plan or aesthetic consideration. So if you want to have up to 3, you can go ahead and do so without a development permit. Anything beyond that just would require a development permit so that we understand where it's going to be sited and how it will fit in with the rest of the lot. Sorry, I'm noticing a small typo in here. The maximum height without a garage suite is staying the same, but with a garage suite, I think we bumped it up just slightly to 8.8 meters, which would be about 29 feet. And that was in a discussion with council and some of the other summer villages in terms of what the maximum height of a garage suite accessory building should be, so that there's enough ceiling heights and roof pitch to develop it properly. So I apologize for that typo in there, but it would be, I think 8.8 meters or 29 feet in height, but it is in the current draft bylaw. In terms of the maximum floor area, we kept that to the same, but just added a stipulation that they can't be larger than 2,200 square feet. And that's a fairly significantly sized accessory building, but for lots that are very big, 8% of a lot area can exceed that amount quite considerably. So we just wanted to make sure that horse barns weren't popping up on lots where they weren't appropriate, just in terms of aesthetics and sizes. And in terms of the placement on a lot, we've kept that information the same with the same exception for one small shed in the front yard, or sorry, the one small shed in the lakeside of a lakefront lot, and just clarify some of the language as to what a lakefront lot is and what it can be adjacent to. Building orientation, design, and wildfire management. In your current land use bylaw, as part of a development permit application, the development authority is supposed to have regard for things like daylight, sunlight, privacy, the character of existing developments, impacts on adjacent lots, and building exterior finishes and that sort of thing. So as you provide your application, these are things that the development authority should be considering as to whether it's appropriate or is scalable and appropriate for your community. We've kept a lot of that same content, but we've also added some content requested by council that would ensure that buildings aren't piping or channeling rainwater from the eave system of buildings into the lake or the wastewater system, consistent with your wastewater bylaw policy, but also just best practices for watershed management around lakes, just including content in there about that's how, or sorry, that's a design that wouldn't be appropriate in your community. And we've also included a number of principles from Fire Smart regulations that we've adapted in your summer village, but also Birch Cliff and Jarvis Bay as well is going in that direction as well, to ensure that if in the unfortunate situation where there might be a wildfire risk or a fire on a lot, that we're doing our best in future development to mitigate and minimize the risk of it taking out the rest of your community. So there are just a few building design and exterior treatment requirements for new developments in your community, dealing with cladding materials, roofing materials, and making sure that areas where needles and other potential flammable materials, sorry, not, I guess flammable materials is the right word. Anything that could spark a fire very quickly isn't going to be accumulating in an area, touching onto your home or a new accessory building. Keeping of animals is something that's not currently addressed in your current land use bylaw. Not all land use bylaws deal with the keeping of animals, but we felt it important just to reference the fact that your summer village has a dog control bylaw. And so any keeping of any keeping of dogs in the summer village would be must be in keeping with that bylaw. We've also just put a statement in here just prohibiting the commercial keeping of animals. So if you're operating a kennel or a business for that would involve animals, that's not allowed in a residential community like the summer village of Sunbreaker Cove. We've heard from some summer villages that have had folks that operate dog kennels and doggy daycares of a size and scale that affects their adjacent properties. It's not just taking in a neighbor's dog for the weekend or a family member's pet. Suddenly having 8 or 9 dogs barking in your adjacent backyard while your neighbor's making money off it is probably not something that everyone's looking forward to in a summer village, but it's something that we've included in here as part of direction by council. So let us know if that's in keeping with what you think is most appropriate. The current land use bylaw doesn't really address in this section manufactured homes and park model trailers. And in discussing this with council, council wanted some statements in here that would prohibit the placement of a manufactured home. So that's not a modularly constructed home or a ready-to-move model or something that looks like a stick-built home. But it's a manufactured home is something of with particular dimensions and construction standards that would be what you would find in a mobile home park or a manufactured home park in an urban area. That these are not something that have traditionally been placed on lots in the summer village, and just wanted to make sure that any dwellings that are being developed are of a more conventional aesthetic standard. And also prohibiting the placement of park model trailers on a lot, ensuring that what's being developed and habitated in the community is of a single detached dwelling style, and not something you would find in a recreational vehicle park. Council flagged for us two driveways. In your current land use bylaw, there's maximum width requirements, uh, construction requirements that have to be constructed with asphalt within the carriageway. So the area between your lot and the road, the developed road itself. And in the current land use bylaw also deals with grading to the satisfaction of the development authority. In the draft, we've kept a lot of that exactly as worded or with some minor revisions. But also clarified that driveways, as have been interpreted by the Development Authority, are calculated as part of the lot site coverage. So if you're paving or hardscaping your driveway, that's non-permeable or very impermeable surfacing that could affect drainage on your lot. So we just want to make sure that that's part of the calculation and clarify that that's how it's to be interpreted. And clarifying that development permits are required for new driveways or to increase the driveway size so that folks aren't finding out later on that there's land use bylaw requirements for driveways and having to go through the unfortunate situation of tearing up or reducing their driveway size because they didn't go through that process in the first place. Your land use bylaw is one of the first that I've seen to have tourist home provisions within it. So Airbnbs, VRBOs, short-term rental accommodations. Your current land use bylaw regulates them, requires the development permit for them to operate. It states that currently it states that it can be in the principal dwelling only, and has minimum stay requirements and maximum occupancy requirements that I think have helped us with other summer villages to provide them with standards for allowing tourist homes as opposed to ignoring their existence and allowing them to happen without any sort of framework for enforcement. So I guess thanks to the Summer Village for providing us with a bit of that. As part of this review, we've been able to help a few other summer villages to put some rules in place. The draft land use bylaw kind of maintains those current regulations, but we've just clarified in it that a tourist home can't be developed within a guest house suite or garage suite. That was the intent, and I think the language is in there, but we've just more clearly spelled it out. And same for a recreational vehicle on a long lot. Guest house suites are something that's are addressed in your current land use bylaw. The current land use bylaw allows for you to have one guest house suite on a lot. So that would be space for someone to stay in on a short-term basis or family, friends to visit and have a space to be in or to put the unruly teenagers, whether it's in a garage suite, a standalone building, that it's just overflow accommodation for the lot. There are requirements in your current land use bylaw for height, floor area, for garage suites only. But there's no minimum or maximum floor area requirements for things like secondary suites. So it's a good start, but we've just done our best with working with council to clarify what some of the regulations are for secondary suites and garden suites, we'll call them. So the draft land use bylaw again just enables a maximum of one on a lot. So whether you want a garage suite, a garden suite, or a secondary suite, you can have up to one. It can only be developed on a lot with an existing detached dwelling. So that home has to be there first. May include bathrooms, sleeping areas, and food preparation areas. We've clarified that that's the case. The definition in the current land use bylaw allows that as well, but we've put that directly in the regulations. It's kept those height and floor area requirements, except in the case of garage suites, which we bumped up a little just to reflect kind of what some of the other summer villages were doing with maximum height so that there is livable space above a garage and that roof sloping can be done effectively. It's still less than what the maximum height requirement would be for a dwelling. So we wouldn't be in situations where the maximum height of a dwelling is the same as a garage suite. So those garage suites won't be quite as big as the biggest buildings in the summer village. And some additional regulations added in there as well to make sure that all health and safety code requirements are met and satisfied. Into the land use district. So one of the things the land use bylaw does is it has a map within it. In the case of the city of Edmonton, it will zone or divide the entire city into 20, 30 different land use districts that deal with things like single detached dwellings and duplexes and apartment buildings. But your land use bylaw currently today has a land use district map within it that has 3 different districts. So you have your residential district and 2 public lands districts. So that's the environmental open space district, which deals with lands along and adjacent to the lake, and your community reserve district, which are municipal reserve and parcels that are further inland but provide recreational and environmental components to your community. We have not made a ton of changes to these sections. The land use districts, in talking with administration and council, they seem to be working. We didn't add new ones. We didn't delete anything from your land use bylaw map. Properties aren't being rezoned or the districts aren't changing. So another typo in here. I have Batula Beach. That was a summer village we worked with very recently. But it identifies the different land use districts in your community. And within each district, so the residential district is probably the one that's most important to anyone in the summer village. It identifies what those permitted uses are. So the uses that you're allowed to develop, if you satisfy all the requirements of your development permit, that it's something that has to be approved, and your discretionary uses. So things that the development authority might have to think just a little bit harder on as to whether it's an appropriate use of the land. Those uses are all listed in that district. We made some minor edits throughout to just improve clarity and consistency and just provide a more readable format. But at the end of the day, a lot of those districts are as they are kind of found today in your current land use bylaw. So in terms of the map, you would almost be playing that game where find 6 different differences. I don't think you could find 6 apart from the fact that the color scheme and the lot boundaries might be slightly different, but in terms of what land is districted or zoned there's not really any changes in here that I can find. There's a few, especially I guess on the southeast end of the community, there's a lot that is owned by the summer village that's not been designated as municipal reserve. That is technically in your current land use bylaws zone for residential development. But knowing that the summer village is not going to be developing it as such, we've included it in the community reserve district. So it's shown in blue as opposed to yellow in the map on the left. And I think there might be 1 or 2 little walkway drainage corridors that would be included as well. So public lands, for the most part, are either blue or green, even though they might have been yellow in the current one. But privately owned lands that are owned by individuals and not the summer village are kept within the residential district. So that's a fair bit of talking on my end. I welcome any questions anyone might have. Just covering on what some of the next steps are. Any of the comments that we received today, again, I'm recording this meeting and we'll have it posted on the Summer Villages website very shortly for anyone who fell asleep listening to me talk, couldn't stand my voice, or that was unable to attend or had to leave early or arrived late. We'll have a recording for you to have a peruse over at your convenience on the Summer Villages website posted very soon. But any comments that we receive will be kind of compiled and presented to council. So whether they're received tonight or in the coming weeks, look forward to receiving emails, phone calls, reach out to our office at any point. We're happy to have conversations as you wake up at 2 o'clock in the morning and realize you should have asked something. Just shoot me an email, reach out to our office or the Summer Village, and we'll be happy to provide you with an answer. But anything that we receive from between now and approximately September 5th, if a few days after, that's fine as well. But we will compile into a report for council that we'll give to them for their consideration. So if everyone, if 100 people wrote in and said, I hate what you've done with the variance provisions in this land use bylaw, we'll have that to present to council. Or if you really like something, let us know. It's not just complaining that we're hoping to get here. We're looking to get constructive feedback and anything that you can, any insight you can provide us with. So we'll review that with council. Council will provide us with some directions to update the draft land use bylaw, and then we will, if council's happy with those changes, we will present this to the community again on your website, and give you the opportunity to have a look at it, and that notification will be presented to community members as well. And then we'll be getting into the consideration of the land use bylaw for adoption. So council could give the land use bylaw in the future, probably in the fall, consideration for first reading, which will set notification requirements for community members and establish a public hearing date. Changes to the Municipal Government Act recently have required any land use planning matter like this, so whether you're adopting a new land use bylaw or doing an amendment to it, that it has to have an online option for attending. So we'll be having, and I think that's been the current practice with the Summer Village, to have Zoom meetings. So the public hearing will have an online component. So if it's in the fall, you don't have to worry about having to be in the Summer Village. There will be that online option for you to attend. And the public hearing is a formal opportunity for community members to not ask questions, but to present information and testimony before council for their consideration of the land use bylaw. So if you feel that at the end of the day, what's presented at the public hearing is still not quite right, if we're not getting the recreational vehicle section properly or accessory buildings, you let council know what your thoughts are and what you think it should have in there. And council can carefully consider that and direct changes to the land use bylaw. Or if they feel it's in their interest to make changes that they feel are directed themselves or keep it as presented, that's a decision of council at the end of the day. So council will eventually give a land use bylaw consideration for second and third reading. And hopefully through this process, we'll have incorporated community feedback, whether it's heard tonight or presented in emails or phone calls in the near future and included in that what we heard report. But at the end of the day, what will hopefully go for second and third reading will be something that everyone's had a bit of a thought and consideration for. So I at this point, I'll just take a quick peek at the comment section in here and hopefully be able to answer any of the questions. But I will, if anyone can, I guess, use the I think there's a hand raise function to just indicate that you would like to speak. We'll be happy to have that as well, and all that will be recorded as part of the meeting here. But one of the questions that came in here was regarding the recreational vehicle section. and what changes have been proposed, if any. And I do not have the land use bylaw entirely recorded in here in my brain, but um, I think from what I remember and just looking at the draft here as presented, the changes aren't all that substantive in what how things are written currently right now to what the proposed regulations are. There's language in the current land use bylaw that um, deal with bona fide residents and bona fide guests of those residents. That is a bit hard for the development authority to properly understand, who's using a recreational vehicle on a lot, and who may place one on a lot. So what we've just boiled it down to a maximum one recreational vehicle may be permitted uh, maybe stored permanently on a developed residential lot, so everyone can, have a recreational vehicle on their lot. There are provisions in there to ensure that it's, properly within the entire lot itself and not within the road right away or on adjacent properties or in the ditch system. Um, uh, and that it can be used for whether overflow sleeping accommodation for guests or family members or just stored in general, that everyone can have one. And that's as provided for in the current land use bylaw as well, just with a bit more confusing wording. Um, Ensuring that the towing vehicle is parked entirely on the lot as well and not on the adjacent roadway or the within the right of way. Things that you would expect to be uh, no disposal of gray water or wastewater, or either on the ground or in the Summer Village's wastewater system, and just some general rules about connection of the recreational vehicle to make sure it's not a permanent installation on the lot, that it's being stored and kept on the lot and not becoming the primary dwelling on the lot. But in essence, there are provisions as well for allowing additional ones in special situations, but um, in keeping with the current land use bylaw, there's no significant change to the number that can be kept on the lot. So I invite everyone to have a look at Section 916 recreational vehicles. And if you feel that some of the proposed changes are not appropriate or aren't in keeping with how things are currently or what you would like to see, um, would invite you to have a look at that as well. Jim, did you have a question?
Uh, yes, I did, and also a comment. My question is, you talk about posting comments, and I just like my chat's disabled, and so then the other thing I see is notes. Is there, how do people post comments?
There is a chat function that enables you to send comments to, I guess the host, myself, or the co-host, which is Kara, at the Summer Village. But if you have a question,
Mine says chat disabled, so that's why I'm
um,
just
yeah,
confused.
sorry, I don't know. I have it enabled here. And
Hmm.
I've had chats from a few different folks. So
Okay, well, I just, so basically, if people are having the same problem I have, they could do it via email.
yeah, I've
Doing
just
right now.
enabled folks to unmute themselves if they have questions that they're not able
Yeah.
to get through on the chat here.
Yeah.
But yeah, I've had
And then you had made the comment about the the presentation not correctly showing the guest house suite height change.
yeah,
I'd noticed when you talked about the driveways, the material in the carriageway, it suggested that the current bylaw said it was constrained to asphalt, but actually it's asphalt and gravel in the current bylaw, so that's a
yes,
change.
yes. I apologize for that as well. If you don't mind, I'll just pull up to that section so we can read it to the class and have a better understanding of it. Um, Yes, in the current land use bylaw, it says driveways are to be constructed of asphalt or gravel within the carriageway. And as per council's direction, we've changed that to just be asphalt within the carriageway. Just to have, as I understand it from our conversations, consistent construction standards.
Well, I think that was suggested from the development officer rather than council, but regardless.
Yes. Sorry, in our conversation with council and administration. Yeah. Does anyone else have any questions? I've enabled folks to unmute themselves if needed. Hopefully we don't all have everyone speaking all at once. Craig, I've got a hand up from you here.
Yeah, hi there. Yeah,
Oh, great.
first off, I may have missed it at the very beginning, but I just want to echo Jim's, I guess, concern that we don't seem to be able to put some comments in the chat. And I guess I just want to make sure that everybody who wants to have a say here has a chance to have a say. And that we're just really clear. I guess I've got 2 points. One, just to make sure we're 100% crystal clear on what the feedback process is. Can you just tell us again what the feedback process is to receive written feedback on land use bylaw?
Yeah, so the feedback is anything that we receive today. I'm writing down, we're recording. I will review I guess rewatch this meeting so that we have it all properly recorded. So between the comments from the chat I received and from residents, through as questions that you're asking here right now, we'll have that recorded. But the feedback going forward, you can send me an email. That's probably the best way to do it so that we have it properly captured. But I'm happy to have a conversation as well. Our website, we'll have that information on the Summer Villages website as well. But you can find contact information for us on our website, munplan.ab.ca, in my email there. But reach out via email with any comments that you have. What we're hoping to get is if from this presentation or from your own review of the draft land use bylaw, if you have specific or general observations, we're hoping to get that by about 3 weeks from now, or within that period, I guess is what I'm trying to say. We're giving folks about 3 weeks, 3.5 weeks to get that to us so that we can compile it into a report for council's consideration a little bit later in September, so that we can present what we heard from community members and have recommendations for how to address that content. So if a feedback is, all houses in the summer villages should be painted blue, we can identify that that's, what was observed by a community member, that we may not, necessarily propose any recommended changes on that part. But someone might have a comment on setback requirements that we've missed or feel like it might be a good idea, and we can help council to identify some recommended changes to ensure that that's included. So from today, I would understand if not everyone has read the draft land use bylaw on your website. I think for a lot of community members, this is perhaps your first kind of introduction to what a land use bylaw is in the first place, let alone what some of the proposed changes are. So if this is kind of the stepping stone to reviewing the draft, I fully understand that. There may be a few people that have had a look at it and have comments and questions right away, or might be sending an email in the next day or two. Look forward to those as well. But just hoping that this was able to guide folks in understanding what the land use bylaw is and why things are being changed. And look forward to any comments that you might be able to send in to me.
Yeah. So yeah, thanks. I guess I just want to also ask, really to Jim's other point on the driveway piece,
Yeah.
It being currently gravel or asphalt in the carriageway, and the proposal is we change it to must be asphalt. I guess I'm curious what the rationale would be for that change. I guess what problem are we trying to solve with that particular change, and does it not go against the principle of permeability and minimizing runoff?
Yeah, Kara, I don't know if you're able to unmute as well, and provide a bit of a answer to that, but my understanding was that I think the summer villages were generally looking to go in that direction. I know we've had a few different conversations about that. if you're able to kind of help with an answer on that, but that was the direction that we were given for the carriageway specifically, not necessarily just driveways.
Yeah, I'd have to take a look at my notes again, but I do recall that being more so just the carriageway. So the municipal portion where the driveway, I guess, connects to the road. But like not the whole property driveway. But yeah, I'd have to take a look back at my notes and just double check what that conversation was, if it was between council or what.
Yeah,
If it was a
I'll
request.
check back on my notes as well. I remember that conversation, and we'll like I said, we'll check back on our notes to see if we kind of overstepped our bounds here, but at minimum we'll include that as a comment for council's consideration as to whether to revert back to the current approach to gravel or pave, but happy to um, uh, kind of provide you with a bit of information on that. So Greg, if you want to send me an email on that, maybe we can provide an answer once we get through our notes. Jim, did you have a follow-up on that or a question?
Well, just to Greg's question, I I don't recall the specifics of our discussion of it, but my thought is there was when we did some repaving, we had some issues with and problems people had entering their driveway because of the elevation changes. And so it seems to me if there had been asphalt there, it'd be easier to do it. And I also wanted to clarify that any change in a land use bylaw doesn't mean all property owners that have gravel in the carriageway have to go out and asphalt it. It just has to do with new developments. And the other consideration of having asphalt in the carriageway is uh, it reduces the amount of gravel that makes it onto the road that can deteriorate the road conditions and perhaps cause issues with people riding bikes on the road. So it's somewhat of a safety and uh, infrastructure consideration.
Yeah, thank you, Jim. I'm remembering a bit of that as well in terms of just creating a consistent kind of pathway for folks biking or walking along the side and protecting municipal infrastructure as much as possible. So, Craig, you have your hand raised as well. I don't know if you have a follow-up on that as well, but I'll go back to my notes, and these are type of things that we can re-explore and find out if anything else needs to be guess revised or revisited as part of this bylaw. Jim brought up a really good point in terms of the it not being things that everyone has to do tomorrow morning if this is approved tonight, which it won't be tonight. That this is for redevelopment only. So if you were redoing a driveway or whatever, that would be the standard. So. Does anyone else have any further questions? This is not, as I'll reiterate, this is not your only opportunity to provide comments. You can reach out to me or Kara at your convenience and provide us with some follow-up feedback or have discussions that way. But anything that we get, we'll include in a report to council. I'm not seeing any more folks either unmuting, raising hand, or comments in the chat. Yeah, if you are looking to comment in the chat, I believe you can select just the host or the co-host, but I'll give another couple seconds here, and if there's no more, we'll let everyone get on with their evening. It's a beautiful night here in Edmonton. Hopefully it's the same where you are as well, and again, thanks everyone for giving your time. Everyone's time is precious, and we really value having you here and be a part of asking questions and getting information and hopefully making this land use bylaw the best it can be for the community. So, not seeing any further, I will end the conversation for the time being. But reach out to me And if you, when we send this recording along to the Summer Village as part of the YouTube link so you can watch it later, we'll have that contact information for myself and Kara included as well. So if you want to call or send an email, be happy to hear you. That having been said, I will end the recording.